Good morning, everybody. My name's Jeff Weiss. Welcome to the Bond, Schoeneck and King Spring 2025 Special Education Update. So glad to see everyone in person and everybody who is Zooming online. Good morning as well. This is our second day in a row doing this program. We were in Rochester yesterday. So we worked out the jokes should be much better today. We tried a few out. Good to see everybody today. We have a jam-packed agenda today. We got an all-star statewide panel of special ed attorneys here to bring you the content you need. So what do we have in store for today? We're going to start out with Ann McGinnis, who is going to talk about school psychologists in the CSE process, practical and legal guidance. And so, Ann's going to start us off. Afterwards, when Ann's done, I'm going to speak on FAPE 22, everybody's favorite issue. When does the eligibility for a FAPE end for students with disabilities who haven't received a diploma? And that's a really dynamic issue these days with changes and myths and so on. So we're going to really get into that. Afterwards, Andrew Mark is going to talk about not one, but two ways to place a student with a disability in an interim alternative educational setting. And we're seeing with the shortage of programs these days, there's more kids than ever who require placement in an IAES. So Andrew's going to talk about that. Then we're going to take a break. And then hopefully you're not going to run out of here screaming. And then you're going to come back. And then we're going to finish up strong with two very important topics. Number one, we're going to talk about OCR, what's left of OCR, or OCR, the new version of OCR, all the changes, because these days OCR has a lot of investigations pending. And then we're going to finish up with something lighter, sports. Everyone loves a little sports to end the day. Accommodations for students with disabilities in the sports setting. What's important to remember, though, is that the rules that we are talking about for accommodations in sports apply to all extracurricular activities as well. So these are very important principles that, especially now, it's the weather's getting better. There's more sports. There's more end of the year field trips and so on, more events. The accommodation issues are coming at us fast and furiously. So we're going to get started. Also, if you have a question during the event, this is a dynamic event. So if you have a question, raise your hand and someone will come up to you and we'll have a microphone so that you could ask your question so that the people who are Zooming in could hear it as well. So, and also if you are Zooming in, there's an opportunity to give your questions somewhere on the Zoom site, and we'll make sure that we see your questions. So if your question is too hard, we're just going to pretend we didn't see it and just move on. But most of the time, we'll be able to answer them. So let's go. We're going to get started with Ann. So welcome.
Good morning, everybody. Can you hear me okay? All right, it's nice to see all of you. I was thinking about it. Jeff and I have been doing these programs for almost 10 years now. He did them before I joined him, but I've been here for about 10 years. And I would say that probably 95% of them, the Rochester one is first. So I think it's an on-purpose thing so that Buffalo gets the rehearsed, the rehearsed version. So you guys get the better version here. So I'm going to be talking with you about the role of school psychologists. It says in the CSE process, it's a little broader than that. I think most of you know, but I was a school psychologist. I haven't been for about 11 years now, but I'm talking with that background, but also with a legal background. I think school psychologists are incredibly important in the CSE process. They have a very unique role, and we're going to talk about that. So at the CSE, if it's a full CSE meeting, school psychologists are required members. If it's a sub-CSE meeting, a school psychologist is only a required member if either the CSE is going to be reviewing a psychological or a psychoeducational evaluation, or if the CSE is going to be considering a more restrictive placement for the student. It is permissible to have a school psychologist at a sub-CSE for other purposes. I'm finding that districts are doing sub-CSEs less and less. Most are just having full CSEs, but it is permissible to have a sub-CSE if the district chooses to do that. And the psychologist's role at the CSE, they have a role in every part of that CSE process and in the IEP development. So if there's a psychological or psychoeducational evaluation, the psychologist reviews that and interprets the results, makes recommendations as a result of that evaluation. They provide input about potential classifications. Psychologists have a lot of training on things like diagnosis and understanding how to put data together to determine if there's a classification. It's still a team decision if a student's going to be classified and with what, but the psychologist has input into that. The psychologist can also provide input about potential diagnoses. I'm going to talk about that more and how that applies. The psychologist can assist with developing the present levels of performance. They have special expertise in the social and management areas, but they can provide input in all areas. And then they assist with developing the annual goals with special expertise in the social emotional goals. But psychologists do have unique training on understanding how to develop measurable, observable goals, how to identify baseline data and how that will be used so they can provide input even if it's beyond those social emotional goals. And then providing input about the program services and supplementary aids and supports. The requirements under the IDEA for evaluations, they serve two purposes. So one is to identify students who need special education and who are eligible for classification. And two, to assist the CSE with identifying the special education and related services that the student requires. And to do that, CSEs are required under the law to conduct a full and individual initial evaluation before providing special education or related services to a child with a disability. There are some required evaluations in that initial, and a psychological evaluation is one of those required evaluations in an initial. It's things like a medical evaluation, social history, psychological evaluation, observation of the student in the learning environment. Those are required evaluations. And then any other evaluations that are necessary to identify the student's needs in areas of suspected disability. It is permissible for a determination to be made that a psychological evaluation is not necessary for an initial evaluation. That's when the psychologist determines that there's no need for additional data. They have to prepare a written report of that assessment, including a statement of the reasons that the evaluation is unnecessary, and that should be reviewed by the committee. But I don't like this. I don't think that we should be using this much, if at all. I think that a psychological evaluation is a very important component of an initial eligibility meeting, and it would be a very rare circumstance that it wouldn't provide helpful information. We have an obligation to assess in all areas of suspected disability, so it's always risky when we say, we don't have to do that required evaluation. It is permissible if we use these procedures, but I would not use this very often. Just my own personal opinion on that. I think it's more defensible when we have a psychological evaluation conducted. For reevaluations, we know that reevaluations have to be conducted at least once every 3 years, not more than once a year, unless the parent and the district agree otherwise. And when a student is due for a reevaluation, there's supposed to be a process. I don't know that it happens this formally in practice. Maybe it does in your district. It didn't in my district, but there's supposed to be a process where a group that includes the CSE, but other people too who might be relevant, to review the existing data and consider input from the parent to determine if any additional data are needed, to identify whether the student continues to have a disability, to identify the student's present levels of performance, the student's needs, and whether any additions or modifications to the special education services are necessary for the student to meet their measurable annual goals and participate in the general education curriculum. If it's determined that we don't need additional data, then there are circumstances where the district and the parent can agree, maybe that 3-year reevaluation isn't necessary. There's a provision of the regs that say that we can still do a records review, and that provision actually says we don't need parent consent to do a records review, but I prefer for the records review in lieu of a 3-year reevaluation to be a little more formal and include a written report that summarizes that for the CSE to consider. And so I think it's probably best practice to get parent consent for that, because we are generating a report and we're probably going to consider that to be the reevaluation and use that to change the reevaluation year. Let me see if I have a slide on this. I do. Okay. So as far as what goes in a psychological evaluation, the regulations don't say what types of assessments or areas we need to assess. Some people think every psychological evaluation has to have at least a cognitive and achievement, and that might be best practice in most situations. There's certainly nothing wrong with collecting that information. I'm very old school. I think that cognitive testing is helpful with identifying where students should be achieving, identifying strengths and weaknesses in the student's cognitive profile, and achievement testing is helpful to help us understand how the student is accessing the general education curriculum. Even though achievement testing doesn't always align with the curriculum, it still gives us a norm-based standardized assessment of how the student's performing compared to other students of their same age in our country, which is helpful data. But we also have to assess in whatever areas of suspected disability or known disability for a reevaluation. So that could include things like executive functioning or anxiety or behavior, a lot of other things that psychologists can include in their evaluation. It should be individualized for the student. We need to make sure that we ask for parent consent for any area that we're assessing in. It's important that the assessment results are included on the IEP. I also like brief summaries in the PLEPs, maybe a sentence or two about the cognitive profile in the PLEPs, some summaries of how the student's performing academically. And when we're considering if we need to do the reevaluation, there's some considerations that I think are important. One is the student's age. The younger the student is, the more important it is that I believe that we do that reevaluation every 3 years, because things are changing so much. I've had cases where students are 10 and we haven't done any formal testing since CPSE, and that's too long. The CPSE stuff isn't relevant anymore because students change so much when they're younger. So the younger the student, the more important it is, I think, to make sure we're doing those full reevaluations. And just to be clear, I like to do those full reevaluations every 3 years. If possible, I think that's best practice. But I understand that we live in a world where we're short-staffed and it's difficult to do, and sometimes we need to make decisions based on individual student situations. Other things to consider are the student's disability-related needs. So let's say we have a student who is in 9th grade and we've given that student 3 cognitive assessments over the years, and every time they're solidly average in every area. We probably don't need to do a cognitive assessment for that student again in 9th grade, but maybe we want to collect other data. Maybe that student has a learning disability in reading, so we think an achievement evaluation could be helpful. Maybe the student has behavioral needs, so we want to do some rating scales to identify how they're performing. I've had psychologists ask, why are we doing rating scales if we already know the disability or if we already know the diagnosis? And it's true, rating scales can be used to help with diagnosis, but they also give us a norm-referenced idea of where a student is performing compared to other peers, which can help us identify needs. And if parents especially are seeing a lot of concerns at home that we're not seeing at school, gathering that data from school, the student, and the parents can help us identify if it's a school-related need, and if so, what area it is. So we can use that to inform areas to target on the IEP, even if it's not being used for diagnosis. And then we should also consider how much time has passed since the student's previous evaluation. I think it's risky to skip the reevaluation twice in a row. So if we didn't do it the last 3-year cycle, it's important to do a full reevaluation the next time. These aren't legal requirements. These are just tips that I've seen. It's always going to be more defensible if we have a more recent evaluation that identifies the student's abilities and needs if we end up at due process. The evaluations are a very important part of the due process hearing. Something else that I've noticed is it's risky to rely only on private evaluations when making recommendations for students. So I've seen situations, and I did this sometimes as a psychologist, where a parent will go out and get a private evaluation and submit it to the CSE, and we review it and we say, well, this assesses all the areas we would assess. There's no need to do additional testing, which in a lot of ways is a student-centered way to look at it. But the risk with that is if there's recommendations in that private evaluation that we don't agree with, if we haven't collected any of our own independent data, it's very difficult to say the student doesn't need that. So if we have concerns about any of the recommendations, it's better to have our own evaluative data and any other data that we have to help us make that decision. Otherwise, think about it. If we end up at a hearing and we don't have our own data and they bring in this expert who did this evaluation who says the student needs everything, it's very difficult other than our observations to say that they don't. And data always makes our case stronger. And I talk about hearings because that's the worst case scenario. Hopefully you'll go through your whole career without one. But if you are in one, the more data, the better position we're in. All right. Oh, question?
Sorry, does someone have a hand up?
Over here.
Oh.
Sorry.
It's very official. Hi. So in our district, some of us as CSE chairs, when we have a family bring in a private evaluation, let's say it's an autism evaluation or a CAP evaluation, some of us are holding those as re-meetings because we're considering classification or maybe like addition of services or things like that. Is that regs that we need to hold that as a re-eval because we were reviewing an evaluation, or would a program review suffice?
So the regs don't really specify, in my opinion, if it has to be a reevaluation meeting or a program review meeting. I think you can probably call it either. And the regs also don't specify that if you call that a reeval meeting, that you have to change the reeval date necessarily. Maybe you will. It'll depend on the situation. So I think you're fine. I think what matters is that you have the meeting and you consider it and that you keep an eye on that reeval date, because sometimes we accidentally keep pushing that off because, oh, we did a speech eval this time and we reviewed a private eval this time, and then we realize years have gone by before we've done a full evaluation on a student. We have a question back there. Thank you. Do you have something you want to say about that?
No.
Oh, okay. Okay. Yeah.
Just a follow up to that. So if you considered it a reevaluation, would you then have to do like your own observation and the other components required for the reevaluation?
No, you don't. So the reevaluation doesn't have the specific requirements of what has to be in it like an initial evaluation does. It's probably best practice when we do a reevaluation for it to include those components, but it's not necessarily legally required. The regs don't define what has to go in a reevaluation to be considered sufficient to change that reevaluation date.
Sorry, just another follow-up question. So if we receive an evaluation from a family and we hold a CSE meeting, are we required to, prior to that meeting, create a PWN for parent consent to review the evaluation that they submitted?
No. Okay. Yeah. No, we only need parent consent if we're conducting the testing. We're legally required to convene the CSE and review any private evaluations that a parent submits to CSE. So we always have to consider and review those, but we don't need parent consent if we're not doing any of our own testing. Okay, great. My last tip on this slide is I prefer for psychologists to not include substantive recommendations in their psychological reports. So when we go through training to become a psychologist, we are given a lot of training on developing recommendations and including those in our report. I used to have pages and pages of recommendations when I was in grad school. But it's risky to include those recommendations about potential services or accommodations or classification within a report for two reasons. Number one, it can look like predetermination. So predetermination is when decisions are made outside of the CSE setting. and putting recommendations in could look like predetermination. But number two, and maybe more important, is any decisions that are made are a CSE team decision. And it can look like and I'm not saying anybody has any like bad intentions here. I truly don't think anybody does when they're doing this, but it can look like maybe the school psychologist is making decisions independently of that team. And it also puts the district in a difficult position if the CSE doesn't end up adopting those recommendations. And I have had situations where parents have said they're going to call the psychologist as an adverse witness against the district because the district didn't adopt the recommendations in the psychological evaluation. And that's not a good situation. I don't want to be in that situation. I don't want to treat a psychologist as a hostile witness. It's not a good situation. I think that the recommendations that psychologists have are important and crucial, but the time to share those is at the CSE so that the team can consider them together around the table and decide together what recommendations to adopt. I had psychologists once push back on me about this. I had a conversation with them, with their supervisor. This was years ago. And they said they're legally required to put recommendations. And I said, where's the law for that? They gave me law from California. So that's why you need a lawyer, right? So in New York, there is nothing in the law that requires us to put recommendations in a psych report.
So I always end my reports with the CSE should discuss blah, 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 and then is that?
What I like it to say is all recommendations will be made at CSE.
I always add in the report.
The end. That's it.
All recommendations regarding eligibility.
All recommendations will be made at CSE.
So don't
put a summary, synthesize your work, right?
Right.
And then all recommendations will be made at CSE.
So no, like discuss this or this. No. Okay.
No, I don't like it. That's an Ann McGinnis preference after having to go through this over the years. And also as a psychologist being told, when I started down on Long Island back in 2009, you have to write your reports this way, and really me pushing back hard on that and having to talk with our attorney about why that was important. So I guess that stuck with me all these years later. Yeah. All right, Section 504 evaluations. I'm going to go over this a little more quickly. A lot of teams don't realize that we are supposed to conduct Section 504 evaluations, both for initial eligibility determinations for Section 504 and for reevaluations. Now, it's not as stringent of a process as it is for CSE under Section 504, and the information you collect can really be dependent on the reason for the referral. So if you have a student with diabetes who only needs medical accommodations with a nurse, you don't need to do a full psychoeducational evaluation with that student. If we thought the student needed accommodations or other supports, then maybe you would. It really depends on what we think the student needs. We're more likely to see a need for psychological evaluations for Section 504 for things like anxiety and ADHD, which are probably the two biggest reasons that students are asking for 504 plans. And in those situations, I'll just walk you through an ADHD 504 evaluation that I think is best practice. Obviously, it's dependent on the student, but if we don't have any academic concerns about the student, psychological evaluation could include something like a classroom observation, consultation with the parent and teacher, a clinical interview with the student, and maybe some rating scales. So it doesn't have to be a full psychoeducational. We would still call it that because it is, but we don't have to automatically do a full cognitive and achievement. It's really tailored to the needs of the student. And again, back to, yes, maybe we're not diagnosing, or maybe we are, right? There's no need to have a diagnosis to be eligible for Section 504 plan. There's no need to have a diagnosis to be eligible for any of the 13 special education classifications. Sometimes teams think that they're important, and if so, we need to pursue that, but it's not legally required. But an evaluation can help us determine if a student has a physical or mental impairment that substantially limits a major life activity, which is the legal standard for 504 evaluations. We have a question over here.
This is kind of just for me. I just want to hear it repeated for 504. you don't need to have a documented diagnosis.
You do not need a documented diagnosis for 504 eligibility. You don't need a documented diagnosis for CSE eligibility. Having a documented diagnosis does not automatically make you eligible for 504 or CSE. It depends on the circumstances, and this is why the data we collect is so important to help us determine if those legal standards are met. For 504, a physical or mental impairment, nothing about diagnosis, that substantially impacts a major life activity. And for CSE, meeting one of those 13 special education classifications, and there's criteria, there's a definition for all of those classifications, and because of that, being in need of special education. Those are the two standards that we need to meet for eligibility if we think as a team that we need a diagnosis. So when I was a CSE chairperson, I preferred to know if there was a diagnosis if we were considering an emotional disability classification for a student. Not legally required, but I just felt like it was best practice. I'm also a licensed psychologist, so I would say, can I determine if there's a diagnosis based on my evaluation? And we're going to get to this. Legally, yes, I could, because I was a certified school psychologist working in a school, but my school didn't want me to engage in diagnosis, and that was fine. That was not what they wanted their psychologists to do, so we would contract with a psychiatrist to come in as part of that evaluation. We cannot require parents to give us an evaluation to determine eligibility. So there's two reasons for that. And I used to tell parents this all the time, and it was wrong. I used to say, well, your child might be eligible for a 504, but we don't have a diagnosis, so we can't get there. If you give us one, then we can reconsider. That was illegal. We can't say that. Luckily, the statute of limitations has passed for that, so I can admit this now. But so there's two reasons why we can't require parents to give us a diagnosis. First, we have to provide students a free, appropriate public education. That applies to both IEP, CSE, and 504. And telling parents you have to go out and get a diagnosis is not free for them. And number two, we have a child find obligation to identify, locate, and evaluate all students with suspected disabilities. So we can't place that responsibility on the parents. If they have a diagnosis and they share that with us, and if that's sufficient, good. We don't have to go out and then get our own diagnosis. But we can't tell parents, but for you getting a diagnosis, we can't find your child eligible. Yeah. Sure.
And there was a question online about, there was discussion about the procedure for reviewing IEEs submitted by parents. And does it matter the type of report? Like if it's a neuropsych versus a speech versus OT, does that impact the procedure?
I don't know if I understand the question. If we get any kind of evaluation report, we have to review that through CSE.
Right. So it's the same procedure followed every, yeah. It doesn't.
Do you think that's related to me saying that if we don't do our own, then it's tough not to accept their recommendations?
I don't know for sure from this, but
if so, yes, it's for any type of evaluation. Yes.
Yeah. So it doesn't matter if it's a neuropsychological versus an independent neuropsych versus independent speech. In terms of calling it, we talked about, do you call it a reevaluation?
Yeah, same considerations for all of it. I would be hesitant to call an independent evaluation the reevaluation and change the date, but there might be times where you think that that's relevant. It should be an individual decision made based on the circumstances. All right, I'm going to talk about FBAs very briefly. So we know that we conduct FBAs when we think that a student has interfering behaviors to determine the function of those behaviors, and we develop a behavior intervention plan if the FBA tells us that the behaviors are significant enough to warrant a BIP. And psychologists don't have to conduct the FBAs and BIPs. The regs don't say who. It could be anybody who has expertise in conducting FBAs and BIPs. That's frequently psychologists. I think all psychology grad programs probably have training on FBAs and BIPs. I prefer for it to be a team approach. That's not required either, but I think that that is in spirit of the regulations, led by somebody. It could be your psychologist. It could be your behavior specialist. It could be a lot of different people. But it is usually psychologists are part of that. All right, I said I was going to get to this. School psychologists and diagnosis. So there's a lot of confusion out there about the legal ability of a certified school psychologist to engage in diagnosis. And just this week, I heard a school psychologist say at a CSE meeting, I cannot legally give a diagnosis. That is incorrect. I think that there's a lot of confusion about this. I think the training programs aren't training people the right way around this. But under the education law that governs the practice of psychology, which says that licensed psychologists, not certified school psychologists, licensed psychologists can engage in assessment and diagnosis, among other things. There's a carve out that says a certified school psychologist who is employed by a school can engage in all of the activities within that setting that a licensed psychologist can engage in. So that would include assessment and diagnosis. Now, some caveats. Not every school psychologist has the clinical competency to engage in every diagnosis. They may have it in some and not others. And we also need to make sure that our psychologists have the tools to be able to effectively engage in diagnosis if this is something that we want to consider. There are some districts that are having their school psychologists be trained and supported in diagnosing things like anxiety and ADHD, because those are two referral questions that come up so much that they just want to do it in-house, so they're not bringing in outside people. And they're supporting their school psychologists with that. They're giving training. They're giving them the materials to do that. They're giving them supervision around that. And that's great. That's legally permissible. But I don't think it's a good idea for a certified school psychologist to hear that and say, I'm going to go out and diagnose now. I don't think that's a good idea. It should be a decision that is made with administration and the psychologist together. And if it's a decision that the district's going to move forward with, which the majority of districts are not, but it's something to think about. It's a decision that should be made together, and it should be very carefully thought out and planned. But if you are in a position where your district feels like, we feel uncomfortable saying that a child needs a 504 plan due to anxiety without an actual diagnosis, which you don't need, but we feel uncomfortable with that, this is one way to be able to do that within our own psychological evaluations that we're already doing. Or we could say things like the student exhibits symptoms consistent with anxiety. For some reason, that makes people feel better than just coming out and saying this child has an anxiety disorder. Either is fine, just something I wanted to throw out there. And if your psychologists are saying I can't legally engage in diagnosis, please ask them not to say that, because it's inaccurate and it causes a lot of issues with parents who then say, well, then I want an IEE if you can't tell me if my kid has this or not. So things that are pretty simple for us to do, like dyslexia, dysgraphia, and dyscalculia, call it dyslexia if we all think it's dyslexia. We're legally able to do that. The CSE can identify that. If you're finding a specific learning disability in reading fluency, the kid probably has dyslexia. So if a parent would just feel more comfortable knowing if they had that diagnosis or not, I wouldn't be afraid just to say that they do through the CSE process. And as long as you're collecting sufficient evaluative information to get you there. Manifestation determination reviews. We know that we need to do these when students are going to be suspended for more than 10 days in a row or for 10 non-consecutive days in a school year, and the most recent reason is a pattern. And at the manifestation determination review, the team has to answer, was the misconduct caused by, or did it have a direct and substantial relationship with the disability, or was it a direct result of the failure to implement the student's IEP? And a psychologist is not a required member of a manifestation. The regs are pretty vague about who needs to be at a manifestation, but I think they're really crucial members. Because when we're talking about, was it caused by or directly or substantially related to the disability, we're not talking in broad, can ADHD cause this? This child has ADHD, could ADHD cause this to happen? We need to get very specific and say, have we identified this student's ADHD-related needs as including this type of behavior? Because kids with ADHD have all different types of needs. Not every kid with ADHD is impulsive. And if they are impulsive, it doesn't automatically mean that if this is an impulsive act, it's definitely related. It depends on how we've identified their impulsivity and if it's the same as this type of act. And psychologists can really help with that. That's the role of the psychologist, is to go in and synthesize the student's disability-related needs together with the rest of the team to help lead that conversation about, do we think for this student's needs, is there a connection with their disability? A psychologist should not go into a manifest and say, well, I don't know this child, I haven't reviewed their folder, but I could generally say what ADHD does. That's not good enough. It's part of the psychologist's job to be familiar with the student's needs before going into the manifest so that they can have a specific discussion around that. All right, we're going to close with student counseling considerations. And in New York, there is no privileged relationship between a student and a school mental health provider. So that includes the school psychologist, the school social worker, and the guidance, or well, I should say the school counselor. I'm sorry. I know we're not supposed to say guidance counselor anymore. So it's like saying gym teacher, right? It's like we're not allowed to say it. Okay, so there is no privileged relationship. This is something that our mental health providers sometimes don't fully understand. And again, it comes back to a training thing. So obviously, if you're in a private practice situation, there is a privileged relationship. But if you're in a school setting, there's not a privileged relationship, which means if an administrator has a legitimate educational interest in knowing what we're talking about in counseling, let's say we have concerns that the student is making threats of violence against self or others, and the administrator says, I need to know if the student disclosed this. It would not be appropriate for that school mental health provider to say, I can't tell you, it's confidential. Because the law that governs is FERPA. And under FERPA, anybody with a legitimate educational interest has a right to know about that confidential student information. And an administrator who's concerned about safety would have that legitimate educational interest. That's just an example. The other situation where this comes up is if parents want to know what's happening in school counseling. We can't really tell them, I can't tell you, it's confidential. FERPA gives parents the right to know their child's education records. It doesn't mean we have to call them up and report everything the kid says. And we can use some clinical judgment in how we report out to parents if they want to know. But we can't say to a parent it's a confidential relationship because it's not. Parents under FERPA have a right to know what's happening. It's really important that you explain those boundaries and those limits on confidentiality to students. It's really important that if they disclose something to you or if they look like they're about to disclose something to you that might be particularly sensitive, that you remind them of that as much as you can. If something is going to be disclosed, try to talk to them about that first, because that can damage the therapeutic relationship. But it's important that our providers know that it really is not, obviously it's confidential in that we can't just go out and tell anybody what was talked about. It is confidential in that way. But individuals who have a right to know under FERPA, we have to share that with them, with limited exceptions. So right now, the state guidance, for example, says that if a student identifies as gender expansive and doesn't want us to tell the parents, then we shouldn't do that. But that's a very limited exception. Question back there?
So just a question. I thought I'd heard somewhere that like a school counselor or social worker, psychologist, if they have like their own sort of personal reference notes, that's not something that would necessarily be part of the educational record. Would that be one of the exceptions you were talking about?
Yeah, I have a slide on that.
Oh, you do?
Yeah,
okay.
I'm going to get to that next.
Can I ask one other quick question?
Sure, yeah.
We have a family support center that is affiliated with the school. I'm sorry. I know. I saw the face. That's affiliated with the school district. It's not an Office of Mental Health certified agency, but it's also not I would not characterize it as an educational institution. So we kind of operate that, the records are confidential and that there are obviously circumstances when they can be released. But I'm just wondering if, the kids don't go there independently, they go there with their families. So just if you can maybe speak to that sort of unique and annoying scenario, that'd be great. So
I think those are really helpful things, but it truly depends on how that is set up. It depends on the contract between the district and the entity, and it depends on how it's actually playing out. So I've had situations where we have outside people from local, agencies come in and the school treats them as a full member of the team. They go to RTI meetings. They talk about kids. I don't know if it's legal based on that particular contract, but they are receiving educational stuff. I would say in that situation, they're a school official. They're acting like a school member, a member of the school, which means FERPA applies. If they are a totally independent organization that's only essentially renting space at the district, then HIPAA would apply to them and we would need consent to give them information or for them to give us information. And they would have to follow their own rules related to disclosure and things like that. Yeah, so it really depends on how those entities are set up. And a lot of times the contracts don't explicitly spell that out. And a lot of times it's very blurry. So yeah, something to think about. I've had situations where people have come in and provided services to students. They're like a member of the team, and then they've refused to provide their notes to district administration. That's not allowed. I've had to write letters to them saying, you are governed by FERPA. You're a member of the school team. HIPAA does not apply. But again, it depends on that legal relationship. Question.
So I might have missed it, but we have a similar situation at ours where we have an FRC and the practitioners in there are the school staff. They are there for like 1 day a week and treat families and students. I don't know that it's always students with their families. So how would that work? Because it's like, it's in our building, it's our staff, but it's not in the school building necessarily.
Yeah, who's paying them?
Our school district.
It's part of their salary?
Yep.
Yeah, I think it'd be a FERPA thing.
Okay.
Yeah. Which means what we're talking about now would apply. But that's like my guess with knowing very little information, disclaimer, right? So I would have to know more to say for sure.
Yeah, sometimes there's a staff member will have a school psychologist will have a private business and they'll actually counsel students. And you have to look closely at exactly if this is separate or not. It's really not ideal. And I've even seen situations where there's confusion from the outside world where like someone will subpoena the psychologist for work done in the private setting, but it's perceived as through the school setting. And they try to, is school coverage apply? And so it's a reality of it, but you really have to be careful with how you set that up. And then, by the way, it doesn't end with FERPA 2D. Like you got a lot of document retention. Like there's a lot of things that could be triggered if you think it's private, but it's not. So,
I think there's a real ethical issue to somebody having a private practice with students from their school. So I think that's something to discuss with the district and come up with some boundaries and parameters around that.
So just to clarify, not a private practice, social workers paid by the school. Part-time is going into 8 o'clock at night. Part-time is seeing students during the school day, all out of the school buildings paid by the school. They cannot say to high school principal, you are not allowed to know who I have consent on to see. They shouldn't.
I would need to know more, but I have a hard time understanding how if the district is paying for the service, that it wouldn't be governed by FERPA and 2D and all that other stuff. Yeah.
yes, I know we're going a little over, but this is very important, obviously, by all the questions. So, anonymous attendee, right?
Okay. Welcome, anonymous.
Okay.
Yeah.
So we are permitted. This is a nice leading question for those who want to be lawyers. So we are permitted to disclose information during school counseling sessions with parents, not only when safety is a concern.
Yes.
There you go. Yeah.
And required in certain situations. Yeah. And the kids need to know that before we start that relationship, and they need to be reminded as we continue to maintain that relationship. All right. I'm going to try to catch us up a little bit. So these are 2 commissioners' appeals where the commissioner said there is no identified privileged relationship between a school mental health provider and a student. Okay, notes. Under FERPA, most of the notes that we take are education records, which means that parents have the right to review and inspect upon request. It doesn't require us to affirmatively give it to them, but they have the right to review upon request. This is why, because an education record could include information that we just have knowledge of for a student. That's why if they ask us how is counseling going, we have to give them a substantive answer in some way about that. It's not an education record. There's other exceptions, but the one that applies most here is if it's a sole possession record. So that means that it's kept in the sole possession of the maker, used only as a personal memory aid, and not accessible or revealed to any other person except a temporary substitute for the maker of the record. But it can still be subpoenaed. So there is still a universe where you have to produce it. But under FERPA, if it's your sole possession record, it doesn't have to be. When I was a school psychologist, I wrote most of my counseling records knowing that they're not sole possession records. I wanted the next psychologist moving up to know what we worked on, and I had nothing to hide. I was okay, but I was aware of what I was writing. Right? You don't have to write down everything. And if you're taking notes as part of your IEP goal data, you can't call that a sole possession record because parents are entitled to see the IEP data. If a student disclosed something to me that was particularly sensitive, I had a separate file unrelated to kids where I would jot it down if I felt like I wanted to remember it. And that was my sole possession record. But I was aware of the counseling notes I was taking were for the most part education records and that parents could review them. We're also required to disclose communications. All this time I've said we only have to disclose if parents ask, but we are required to disclose when we have knowledge that a student has defective sight or hearing or a physical disability or other condition which may require professional attention with regard to health. This comes up in counseling. And this Port Washington Teachers Association decision, the court opined that could require us to disclose a student's pregnancy status to parents. It didn't come out and say we have to, but it said under this regulation, we probably do have to. So something to think about. As much as we can with students, we should try to work with them so that they feel comfortable disclosing to their parents, or work with them so that they know that we'll disclose, or work with them so that we'll disclose together, right? We should try to do that. If it's an emergency, we might not have time for that. But if we are aware of a student's health condition in some way, we have to tell the parents that. And it's probably good to seek out some supervision from an administrator before you make that call if it's a sensitive situation. Okay, thank you.
I gave a second one just in case. Good morning. Now, I apologize. During the introductions, I forgot to introduce our co-leader of our education group in Bond, Schoeneck King. That's Candice Gomez. Candice, thank you so much for coming. Candice is one of the top school lawyers in the state. She practices in Long Island. She knows everything. That's pretty much students, personnel. So we're just so glad she's able to come up today and join us for the program. And she'll be presenting later on OCR. But thank you again, Candice, for coming up. All right, let's go. This is, you want to be a lawyer? You're interested in being a lawyer? Let's talk. Because we got to put on our lawyer hats here. It's about FAPE 22. So let's just start with this. If you get a Regents or local diploma, your FAPE entitlement is over. So that's, most kids will get that. Whether it's safety net, superintendent's determination, those kids, once they get a diploma, their FAPE entitlement's done. We're talking about the kids who have yet to receive one of those diplomas, and how long can they stay in school? So this should be a simple issue. If you look in the education law right now, you open it up and it says to the conclusion of the school year in which you turn 21. It said it before, that's what it says now. So why are we here? Let's talk about it. Okay, this is one of the weirdest situations I've ever seen in special ed law. Okay, in 2021, okay, we need to talk for a minute about courts. Ready? Taking notes? You got federal courts. You've got your trial court. The lowest level federal court is a district court. If you have a kid, a high schooler taking like APUSH or AP Gov, this is I remember my son was getting ready. I was explaining. He knew it. I was impressed. So district court. If you want to go for a lawsuit, a trial, district court. You want to appeal, you go to a circuit court. In New York, it's the Second Circuit Court of Appeals. And if you disagree with that decision, New York Supreme Court, United States. District Court, Court of Appeals, Supreme Court, United States. In state court, the lowest court is called the Supreme Court. Okay, make this make sense. Then you've got the appellate division. Then you've got the Court of Appeals as the highest. So this is confusing already. I'm confused. So in 2021, there was a decision in the Second Circuit Court of Appeals. It dealt with a Connecticut case. The Court of Appeals, the Second Circuit, deals with 3 states: Connecticut, New York, and another one, which I forgot. It might be New Hampshire, but it doesn't really matter. Okay, Connecticut case. There was a lawsuit, and the Connecticut plaintiff said, hey, this isn't fair. The kids without IEPs can get education through a free state-sponsored GED program until their 22nd birthday. So why should those kids get education to their 22nd birthday, but the students with disabilities, why does their fate end at this conclusion of the school year in which they turn 21? This isn't fair. The Second Circuit said, you're right, it's not fair. And so in Connecticut, the kids can get a FAPE until their 22nd birthday. Seems strange, right? Like, what is that? It's called common law. There's no statute that says this. It's common law. They had their reasonings. This was not a fluke decision. There were other courts of appeals throughout the country that it went the same way. So this is not a fluke decision. Okay, so now we know that's the rule in Connecticut through the Second Circuit, and we know the Second Circuit governs New York. So there was all this buzz for a while. Everyone is like, there's a decision and it's going to change New York. We probably all heard, I had conversations. It's coming down. 22 is coming. And I was like, what the heck are you talking about? Well, if you think about it, what they're saying is, whoever was worried was saying, hey, a parent can go to an impartial hearing officer, who can go to the state review officer, who can go to the federal court in New York, who would apply the Second Circuit, and they'd apply that same standard. And some people thought if they applied that standard in New York, they'd get the same result, which was 22. So, but the key issue was, well, what's the GED right in 22? What's the GED right in New York? I didn't really know. But so in 2023, SED, legal counsel, issued a memo that basically said, we know about the Second Circuit decision. We know in New York, GED also goes to your 22nd birthday. So because of that, we're telling everybody that you should allow kids to stay in school if they don't have a local regents diploma until their 22nd birthday. They said that's what they're kind of saying is, we think this is an enforceable right in court, so you might as well do it. This is what I was reading between the lines. Now, there's another issue about, it's not really nice to have a child leave midway through, so we suggest that you let them stay, but you really don't have to. If you want to, you can. A lot of schools, more than I thought, allow the student to stay the whole year. It's seen as kind of the nicer thing. Not all, and you don't have to. And there's no question you do not have to do that. You can, on your 22nd birthday, I always say, happy birthday, here's a piece of cake, here's your hat, there's the door. Now you could do that. It's not nice. I don't think, but whatever. But so just so we're clear though, but I think people got confused with the myth of, well, is this optional? But maybe the first part's optional too. The first part's not optional. You have to, under the counseling memo, allow the student to stay until their 22nd birthday. And everybody did that. Everybody knows it. And so again, common law. Now, wouldn't it have been nice if the legislature changed the law to your 22nd birthday? Wouldn't that be nice? We'd be done. I'd be talking about something else. They didn't do that. Wouldn't it be nice if they said GED programs will stop the 21st school year in which they turn 21? Would have been nice. They didn't do that either. So now we're stuck. and we're here. And sure enough, a lot of people were angry about this because it's expensive. There's no extra funding. You got all the certification issues. It's a mess, unfunded mandate. I'm even hearing like some people were surmising, that problems you have with kindergarten, shortages of kindergarten classes, it's because of this, because they can only have so many kids in a building. So if they can't allow get the older kids out, they can't bring in new ones. This is a mess. So now what? Well, it's good old New York, good old US of A. Let's sue. So in March 2024, one district went to New York State Supreme Court. So again, the lowest level of court in a different county. And you have all these issues about jurisdiction, and does a decision of a lower court in one part of the state impact another part versus an appellate division versus court. You got all this stuff. But basically, a school district went to state court and said that this is baloney and this shouldn't be. No. So basically, they're saying this shouldn't apply. And we don't need to go into the specific rationale for why they thought this is incorrect. But they ruled for the school and said, you stick with the way the law is written. And SED said, we're appealing. And SED said, this changes nothing. And on some level, it shouldn't, because it's such a lower court and it's going to be appealed and so on. But still, it got people's attention going, wait a minute, is this okay, and you could have a risk assessment of, well, maybe we'll take our chances and stop all these kids at the 24 at the end of 21 school year, and we'll take our chances. Maybe we'll get sued, maybe we won't. Maybe by the time they sue us, this will be reversed. You got all this stuff, but there's pushback on this. But this is so low level, and it hasn't gone up to appellate division. It didn't impact people as much as you think. So pretty much the status quo is in effect, but again, people are getting emboldened now, though. And so again, in April, they wrote a decision and said, you better keep doing this, stick to it. And then in June, SED wrote and said, look, we're enforcing this. You've got to go to the end of the school year in which you turn up to the 22nd birthday. So SED said, we're holding the line. Okay, now one more decision. A couple of months ago, now we got two decisions against this. It's getting to people thinking, well, what's really going on? This decision, the Mahopac decision, it got more attention than the first one. But again, it's still a lower court in Albany County. So again, procedurally, precedent-wise, who knows the value of this? But but this is getting the attention of, another loss for FAPE 22. But I really think this one, you got to look a lot closer. And if you read the decision, which again, if you're not a lawyer, you're going to say, what is this? But let me kind of explain what this case was about. This was really, I thought, pretty interesting. This was about SED, or Regional Associates' right to enforce FAPE 22. So what this court said was, look, SED, you are a state agency. Your obligation is to enforce the law as written. You're not allowed to change the law. You're not allowed to interpret the law. That's what courts are for. So you have to enforce the law as written. Now, again, do you think somewhere someone would prompt the state to change the law? But that hasn't happened yet. So again, this decision says it's actually like it gets into, and you're seeing this on the federal level these days about how much authority does a federal agency have through these counseling memos to sort of create law through other ways, through interpretation. So it's a lot of heavy stuff in here, but basically all this decision means is, impacts SED's right to enforce it. And again, SED, my understanding is they're doubling down, saying we're still enforcing this, we're appealing this, and so on. We could do this. But that's kind of, so now the question is, where are we? What do we do? What's the answer at this point? Is it 21? Is it 22? So here's our take on it. The second decision, even if the parents prevail, and it's some interesting arguments about a state agency's right to enforce, common law versus statute. Even if the SED is sort of prohibited from enforcing, our concern is the parent could still go to a hearing and still go to the SRO, who's subject to fall in the Second Circuit, and who will still go to the court, which would have to apply the Second Circuit standard. And since the GED goes to 22, now again, no one can guarantee how the Second Circuit would rule, or a federal court in New York would rule. But we know the standard they have to apply, and it seems pretty clear that what they're going to base it on. So it seems clear that unless they somehow reverse the Second Circuit's analysis, which might be hard to do, you might need a Supreme Court decision to do that. There's a very good chance that this rule is enforceable. So the question for districts is, do you want to take the chance and hope this gets reversed later? It seems that for the foreseeable future, for the very foreseeable future, this is the rule in New York, and this is enforceable, and any parent could go in. So, it's funny. I get the feel, I think the lay of the land in Western New York seems to be the status quo. Everybody's sort of embraced. I've got some questions. What do you think of this? There's some confusion. I think in other parts of the state, there is major, major pushback on it. If you were to ask me, what should I do? I would tell you to keep following the FAPE 22, because if you deny it, there's a very, very, very good chance they're going to go to hearing and get it enforced. And then you're talking about attorney's fees and all that stuff. So that's kind of it. Did I make that clear? Like it's a strange time. The statute still says what it says, but again, we know what the courts in New York would have to follow. We know the standard they'd apply. We know the facts they'd apply. It seems clear what the conclusion would be. So that's why, in essence, we're saying this changes nothing. So any questions? Okay. All right. Thank you. And all right on. And here comes Andrew.
You hear, I'm not saying Jeff is at the level of Chappelle, but you hear stories of like comics waiting backstage and Chappelle's on stage just killing it. And then the next guy has to go on and you're like, oh man, you feel so bad for that guy. That's a little bit how I feel right now. So nice to be here with you all. Good morning. My name is Andrew. I've met many of you. It's all right. Let's get into it. So I'm going to talk about the two possible pathways to an interim alternative educational setting. We're not talking about, or IAES, we're not talking about these situations generally unless like something serious has happened or we think something serious will happen. So let's just dive right in. So the first pathway is placement by district personnel. Okay, so under the regulations, a superintendent may place a student with a disability in an IAES in lieu of a suspension if one of the following three conditions are met. Okay, so if a student engages in conduct that has inflicted serious bodily injury on another person while at school, if they've been found to carried or possessed a weapon at school, or the student was found to have knowingly possessed or used illegal drugs. So serious bodily injury, weapons, or illegal drugs are the three categories of conduct where a superintendent can place or remove the student to an IAES. So what does this really look like? And what do I mean by in lieu of a suspension? So we're talking about a situation. We're talking about a situation where we're at a superintendent's hearing. Okay. And, this kind of, we're looking for an extended penalty, and we go to manifestation, and the misconduct was determined to be a manifestation of the student's disability. Okay. So we can't suspend. However, all right, when these three instances, okay, serious bodily injury, weapons, or illegal drugs, we may not be able to suspend because of the manifestation determination, but we can ask the hearing officer to recommend removing the student to an IAES. So that's what I mean by in lieu of a suspension.
Andrew, I'm just going to jump in really quick.
Please.
Okay, so I don't know, I'm not sure out here in Buffalo if the wave that has been going across the state with disproportionality has hit you guys. But there has been a change in the last few years when districts are found to be in disproportionality for student discipline situations where the state is coming in and expecting very onerous corrective action that I frequently think is not supported by the law. And hopefully nobody from the state's listening to this, but I've told them that so they know. So one of the things that they're talking about in that situation that's very confusing is anytime a student is suspended or removed, a student with a disability, they're calling that IAES. I can see why the state is saying anytime a kid is removed or suspended, that is an IAES. It makes it really confusing because we also have these other two situations where kids are in an IAES that's totally different. So we're using the same term for different purposes. And what Andrew's talking about today is how we historically have thought about it and how it practically makes sense for districts. But in case any of you are in that situation, I just wanted to point out that nuance because it is confusing that the state keeps calling a separate thing an IAES. Hopefully that wave isn't here in Buffalo, but if it is, I'm sorry and good luck. Okay.
Okay. So just to put a little bit more meat on the bones to just illustrate the context here. So the commissioner's regulations, we have a multi-layered kind of process when it comes to disciplining students with disabilities. And here's the basic roadmap: the superintendent's hearing, the manifestation, the penalty phase, and then if necessary, a CSC meeting to determine what the IAES will be. All right, so here it is just in more detail. I don't know that I need to go through all this, but essentially what I just already said. If we determine that, we have the superintendent's hearing. If the penalty is going to exceed 10 days for a student with a disability, then we go to manifestation if the student is found guilty. All right. If no nexus is found, game over. If a nexus is found, game over. Usually, if no nexus is found, then you return to the superintendent's hearing for the penalty phase. Okay. Now, if a nexus is found, then that's what I mean by game over. The student must return to their educational placement unless, all right, it involves one of these three categories of, oh, you can't really see that, can you? Serious bodily injury, a weapon, or illegal drugs. If one of those three conditions is met, then we can ask the hearing officer to recommend placement in an IAES for the student. Okay. So what's interesting about this is serious bodily injury has a legal definition, which is very, like most legal definitions, quite often unhelpful to really understanding what that serious bodily injury means. Illegal drug is pretty straightforward, but weapon also is not exactly straightforward. Okay, so we're going to talk about what qualifies as serious bodily injury, what qualifies as a weapon, so you have a sense of when you're in a good place, solid footing to ask a hearing officer for an IAES in those circumstances. And so there might be a factual dispute as to whether or not the student had a weapon. All right. So hearing officers may not like this in a 3214 hearing, but you may have to ask a hearing officer to determine, to put that hearing officer in a position where they have to decide, is this a weapon or did this qualify as serious bodily injury? If they do, recommend an IAES, like practically speaking, at the end, and maybe I'll just save this for the end. So, you know what? I'm not, because I'll forget. So practically speaking, if the hearing officer does recommend an IAES, they'll put that in the hearing officer's report, goes to the superintendent. Superintendent will write a letter, issue a letter saying, placing you in an IAES to be determined by the CSC. Okay, so practically speaking, that's how this would play out. Okay, so the regulations define serious bodily injury as, serious bodily injury, so it's very serious. Bodily injury which involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. So this is, as the term it suggests, I mean, we're talking about serious situations here. This is not, you're going to have a tough time convincing a hearing, like think about what we're asking, a hearing officer to do in this situation. We have a student with a disability, we have manifestation. Nonetheless, we need to remove them from their educational placement. So it's kind of a big ask. So generally, this is a high standard to meet when we're talking about serious bodily injury. Now, it will also always depend on the facts. So here's, you can see this a little bit better than you could in Rochester, but it's not your eyes, it's just the print in the slide. So here are those categories: substantial risk of death, extreme physical pain. This list contains what I would say are some of the maybe more obvious ones. So substantial risk of death, for example, a gunshot wound, knife wound, obviously. So when you get into categories involving extreme physical pain, that's somewhat subjective. Okay, so that's going to be fact dependent. Bodily injury involving protracted and obvious disfigurement. Let's see. Burn injuries there, the loss of a finger or other limb, going back up to extreme physical pain. We'll have a case about this. Injuries to, I'm sorry, I can't read it. Oh, bite-related injuries in which the individual's skin was broken. So that could certainly be a serious bodily injury. And if we go down here at the bottom, involving protracted loss or impairment of a bodily member, organ, or mental faculty, a concussion or traumatic brain injury, severe nerve damage or leg or knee injury that causing lasting mobility issues. And we can even see mental health, mental health effects, lasting mental health effects can help get you over that threshold of meeting that serious bodily injury definition. So like I said, these are going to be dependent on the facts. What is extreme pain to a hearing officer may not be extreme physical pain to us. Okay. So we have to convince the hearing officer that, what we're saying happened. So let's take a look at some cases where hearing officers found where this standard was met and serious bodily injury was found. All right. So if we jump down to, Palo Alto. So in this one, the third bullet point down, biting an aid constituted serious bodily injury. Okay. The bite caused extreme pain and resulted in bleeding and permanent scarring. And actually, when you read this decision, it was pretty awful what happened to this person. It also notes this person had to be treated on the spot by an EMT, was seen shaking and crying. I mean, it was a pretty serious situation. Jumping back up to the top, an administrator had an extreme pain from a bite, punches, and kicks, was treated at a medical center and prescribed muscle relaxers and pain relievers. And this person required physical therapy to regain full range of motion. So being prescribed medication as a result of the incident, that's a good sign that somebody suffered extreme physical pain or had suffered through serious bodily injury. Jumping down to the last one, student struck his paraprofessional, causing her to suffer a severe concussion, which included intense headaches, nausea, light sensitivity, lack of energy, difficulty focusing, and impaired thought processes. So concussions can qualify as a severe bodily injury. And hate to say it, but the more related symptoms you have, the more likely you are to convince a hearing officer that the standard's met. This one is interesting. The second bullet point. So in this instance, the hearing officer noted it was a close call, but found that the counselor suffered protracted mental impairment from a concussion, which she described as the worst headache of her life. So a lot of this is going to be subjective. And it's going to depend on your documentation, which we'll talk about, and your evidence. So I mean, that one was a close call. So a concussion may not satisfy. I think in most cases it probably will, or at least probably should. But you can see that the reluctance on some hearing officers' part to get there. All right. In this one, this is relatively recent. Okay. So during this incident, the student choked a teacher. Other staff had to pry the student's hands away from the teacher's neck. The teacher suffered redness and abrasions of her neck, to her neck and hands, and rated her pain an 8 out of 10. So that's pretty bad. Swelling to her neck and throat made talking painful. She also experienced limited range of motion in her neck that persisted for 2 weeks. And she also suffered anxiety and depression from the incident. So a couple, I think, things to take away from here. Like I said, I hate to say it, but the more symptoms that you have, the easier it's going to be to convince a hearing officer that serious bodily injury occurred. Things like whether or not the individual had to get treated, how many days of school did the person have to miss, if any? Was there screaming? Was there crying going on, when the injury occurred? Did they have to miss any time from work at all? Now, when we contrast that with some cases where bodily injury was not found, so no serious bodily injury occurred where the teacher experienced redness, swelling, and pain, and only missed 1 day of work. So you may, this happens unfortunately fairly frequently, that a staff member may get struck by a student or get hurt. Okay. And they don't have to miss any time at all. It's not pleasant. It's certainly not, a situation that we want to have happen, but it may not be grounds to remove that student from an IAES if they had a little pain and swelling and showed up for work the next day. That's not going to get you to serious bodily injury. Okay. In the second bullet point, no serious bodily injury where principal suffered a migraine after the student punched her in the head. The pain abated after she drove herself home, took medications, and laid down for 30 minutes. So, here we have the pain went away. She came back, she was fine. Unpleasant experience, but didn't qualify as serious bodily injury. Now, incidents like this lined up together may get you removal to an IAES down the second pathway when we'll talk about, okay, when you're worried that more of this kind of situation will occur, because the student is dangerous. It may get you on the second pathway, but not in the 3214 context. And lastly, Malvern, no serious bodily injury where a teen hit an aide's hand causing quote unquote injury. Okay, so that's what we in the legal profession call a conclusory allegation. I was injured. I was injured seriously. Well, you're going to have to show how serious was that injury and why was it serious. And just saying that you were hurt is probably not going to be good enough. Okay, so as I mentioned, whether the incident qualifies or meets this standard is going to be fact dependent. So you may need to be prepared to have the person testify, when you're going through the hearing process, have the person testify about the pain that they experience. I mean, you could do that, when you're asking for the IAES and you have that little mini hearing about whether or not this is a weapon or whether or not this is serious bodily injury. Probably want to just do that up front. But the factors that are going to be considered, can be illustrated or are illustrated rather in that case law. So the IHOs or the hearing officers are going to look at the pain experienced during and after an incident. All right. Was it painful while you were getting slapped? I'm sure it was. Okay. But how long did that pain last? Did you have to get any treatment for it? What was the treatment? If the doctor recommended Tylenol or over-the-counter meds, that's not necessarily indication that you had extreme physical pain if you're taking care of it with Tylenol. Now, the psychological and cognitive impacts of the injury will be considered. And as I mentioned, the extent of the medical treatment. All right. So let's see. Oh, and any time missed off of work, all of those things will be relevant. Okay. So when you have situations, you do want to make sure that you document, okay, what happened. And here's a good illustration of that. All right. So now you get to put on your black robes and be the judge and decide for yourselves, does this count or not? All right. So here's the situation. A second grader with ED, bipolar disorder, kicked the principal's stomach and legs, bit her upper arm through her jacket. The skin wasn't broken, but the area around the bite was sore and reddened. Principal's report was written just after the incident, didn't mention pain, but she did go to the doctor who diagnosed her with an arm contusion, hip, thigh, leg, and ankle abrasions. So she got banged up. All right. This was not a nothing burger. The doctor didn't prescribe pain medication or mention pain in the medical report, but the doctor gave the principal Tylenol as precautionary measure. The next day, the district removed the student to an IAES, asserting the principal endured extreme physical pain. So, what do we think? Extreme physical pain? Was this serious bodily injury? It's okay. I mean, probably to her it was. I'm sure it was to her. But legally, the IHO said, no, sorry, this was not extreme, and therefore she did not sustain serious bodily injury. So here's what the hearing officer noted. The doctor didn't prescribe pain medication or discuss pain in the medical report, and neither did the principal's report mention pain. So if you think, if you're hurt or, if a staff member's hurt, I hate to talk about it in terms like this, but we want to make sure that we document, the evidence, illustrating that if we're gonna base it on extreme physical pain, that the person endured extreme physical pain, we want to know what those factors were. You can always have somebody testify, but having a contemporaneous record of it would be even better. The doctor's decision to give the principal Tylenol as a precautionary measure tended to indicate the pain was less than extreme, probably right. And so the IHO ordered the student to return to his placement. So hopefully that helps illustrate for you what qualifies as serious bodily injury. I think extreme physical pain can be the one that's most subjective. So that's where you really want to have a good record. Okay, weapon. This is another area where you could have a factual dispute. Okay, how could we have a factual dispute over a weapon? Well, lawyers can argue about anything, right? So it has a definition. Another somewhat helpful, but I always love when you see the word that's being defined in the definition itself. A weapon is a weapon. Oh, well, thank you very much. That's very helpful. So it's a weapon, device, instrument, material or substance, animate or inanimate, that is used for or readily capable of causing death or serious bodily injury. All right, we just talked about what serious bodily injury is. That's those 4 categories: substantial risk of death, extreme physical pain, and notice I said substantial risk of death. Okay, that's an even higher, not just risk of death. I mean, that's nothing, right? Substantial risk of death, protracted and obvious disfigurement and protracted loss of impairment or the function of a bodily member, organ, or mental faculty. So there's an express carve out. A weapon does not include a knife that's 2.5 with a blade of 2.5 inches or more. Okay, so that doesn't qualify as a weapon for purposes of this, and now could qualify as a weapon in your code of conduct, but you're not going to get an IAES removal in this procedure if with a knife of a blade of 2.5 inches or less. Okay, so now also to note, we have objects that are used for or readily capable of, causing injury. It does not have to be designed to inflict harm. It doesn't have to be designed to be dangerous. Scissors are not designed to be dangerous, but in some factual circumstances, they could constitute it as a weapon. Okay. Also, intent is not dispositive. So let me give you an example. When you want to remove a student for drugs, we'll talk about the standard is knowingly possessed or knowingly possessed. Okay. There's no intent requirement when it comes to having a weapon. If you have a weapon or an instrument that qualifies as a weapon, just having it on you is enough. Okay. You didn't have to mean to bring it or forgot. Okay. Just having it on you is enough to meet for this. Now, when the object is not inherently dangerous, we think of, that could be, let's say a golf club, for example. Okay. A golf club is not designed to bash somebody over the head with it. Okay. But if it's used that way, that could be a weapon. Okay. So if it's not inherently dangerous, what's inherently dangerous? A knife or gun. Okay. But if it's not inherently dangerous, possession alone may not be enough. All right, and likely won't be. Depends on some circumstances how the object is used, and also, as we'll see, maybe even the age of a student and whether or not that object is readily capable of causing harm. All right, so let's get into it. What is a weapon? We got some obvious ones. Firearm is defined by the Gun-Free Schools Act. I didn't include that whole definition here, but firearm is generally what you think it is. Also includes explosives. A knife with a blade of 2.5 inches or longer. Okay, so if it's, let's see, 2 3/4, that's a knife. Okay, that's a weapon. Seems kind of strange. That's just me. A BB gun is a weapon. Or was found to be a weapon. A metal awl. All right. Any carpenters or handy people in here? Okay. So a metal awl is like a tool about this long, it's very skinny, pointy, and actually, undoubtedly capable, as a hearing officer noted, of causing the loss or impairment of an eye if misused by a student. Yes, we have a question. I think the question was, what about a bullet or a shotgun shell? I truthfully do not know the answer to that question, if that would meet the definition of firearm under the Gun-Free Schools Act. It might, but I'd have to go back and look at that definition. Yeah. Because I know it does include incendiary device, so I just have to look deeper into that, like just the ammunition itself alone. Maybe, I don't know.
What about how they like? Yeah, sorry, yeah. I think.
I mean, if they're like, I mean, I think it's one thing if you have it like like ammunition in the backpack and it's just in there. But that's probably the situation you're talking about. I mean, certainly if they like rig it to explode, that would obviously, I think that no question about that.
Yeah, I think it's like from the bat. Like if somebody has a baseball bat just walking down the hallway, we can't say that's a weapon. But if they were threatening, menacing, then it becomes a weapon. So, I mean, if they were somehow, I don't know, can you like bang like if you said I'm going to take a rock, if they were coming up with a theory to further damage someone in furtherance of damage with that, like I don't know how, but that might be a stretch. But if they say if I throw a bullet at you, it could explode, you might have something there. We might need an expert. And this is where what Andrew said, this is in that penalty phase where usually by that point, a lot of times the hearing officers, they leave because it's unusual for there to be activity of importance at that point. But they would actually have to have a mini hearing on that to figure out if this standard is met. But my gut feeling is, I have a feeling someone could get suspended from school for having a bullet. My gut feeling is it would not meet
this.
Just a guess.
If I had to say so right now, that would be my guess too. But I just say what Jeff says sometimes. I just can't. All right. So scissors, lunging at teachers or other students with a pair of scissors can qualify as a weapon. Maybe a no-brainer. But here's a situation where scissors were not a weapon. So in this case, a student used them in a threatening manner, but they were not a weapon because they had dull blades and rounded tips. So safety scissors are not, didn't qualify in that instance. Okay. So they were not inherently dangerous, not readily capable of causing death or serious bodily injury. So again, facts, circumstances will matter. Also some other examples of things that were found not to be a weapon in these, under these circumstances, I want to say again. So a paintball gun is not a weapon. A pencil was found not to be a weapon. Now, in that case, if I recall correctly, the student was dysregulated and had a sharpened pencil and was sort of like swinging it around and accidentally stabbed another student. So there was not really an intent there. That's different than like saying, I'm going to kill you and pointing a pencil in someone's eye or a pair of scissors. Okay. So again, how if it's not an inherently dangerous object, how that used will matter. So a wrench, not a weapon. Okay. They're going to say this joke yesterday, but in the hands of Colonel Mustard in the library, some people got it. Or Miss Scarlet Okay, a wrench can be a weapon. All right, but in this case, it was in the student's backpack, not touched, not used. Okay, not qualifies as a weapon. Okay, but if you're raising it over your head, probably a weapon. And the last one, plastic phone receiver, not a weapon. Okay, in this case, it was a kindergarten student. The hearing officer actually said it's difficult to imagine any instance where a kindergarten student could cause death to anyone by throwing any objects at anyone at any range or velocity. All right, so if they're throwing jagged rocks at you, it may not be a weapon. All right, it depends on, but a 17-year-old hurling objects at you may be a different story. So there are inconsistencies when you read some of these decisions. You have to really think about why it came out the way it did. But I'll say it one more time: facts matter. Okay, relatively straightforward. The third category is drugs and controlled substances. So now this is where I mentioned that this standard only comes into play if you can prove that the student knowingly possessed or used illegal drugs at school. Okay, so now, interestingly, at the superintendent's hearing, to prove guilt or innocence, for just violating the code of conduct, intent is often not found. There's usually no intent requirement in your codes of conduct. If you have drugs at school, you have them. Okay. But if you want to have the student removed to an IAES in this phase, you're going to have to prove that the student knowingly had it. So what's the student going to say? I didn't know I had it, or so that's somebody else's. So you may have a factual dispute there. Also important to know, a legal drug does not include, medicines used by prescription, okay, or if they're legally possessed under federal law. Okay. Now the distinction between federal and state law is relevant here because what am I really talking about? Marijuana, right? Okay, so in New York, marijuana is legal. Under federal law, it's still considered a Schedule I drug. All right, it is still a prohibited drug. So here are the examples. All right, pulled off right off the DEA's website. Schedule I drugs are heroin, LSD, marijuana, ecstasy. That includes edibles. Okay, and those are more common ones that we're going to see in schools. You may see some of the others. I don't know if you're seeing much Robitussin AC, but that could qualify. All right. Some giggles out there, not many, but okay. So additional considerations. So the superintendent can make the determination to place the student in the IAES. The components of the IAES must be determined by the CSE. Okay, so the CSE has to be and determine the educational services to provide. The duration of the IAES cannot exceed the period of time for which a non-disabled student would be suspended, and the maximum is 45 days. So when you're talking about what penalty you would be seeking, you're not going to be able to put the student in an IAES for longer than 45 days. All right, but you also can't exceed the period of suspension that the student would be suspended for. Okay, now if we're talking about very serious conduct, many times we ask for much longer than 45 days. It's usually not going to be an issue, but just something to be aware of. Okay. All right. So the second pathway, that's pathway number one, or in their context of 3214, the student has already engaged in misconduct and we're, found manifestation. We can't suspend, but we may be able to remove anyway. So we're shifting our thinking here now to where we're worried that the student may hurt somebody. Okay, we're worried the student is becoming dangerous. Maybe they haven't yet, or maybe they have a sort of checkered history of this kind of conduct. But that's where we are here. So the second pathway is placement by an IHO. So in this situation, the regs allow for the district to actually initiate an impartial hearing seeking the temporary placement of a student in an IAES. Now, the standard is you do this when you think the student is maintaining the student in their current placement is substantially likely to result in injury to the student or others. Okay, so that's the legal standard you have to prevail. You have to convince the hearing officer, the IHO, that keeping the student in school is substantially likely to result in injury. There's no requirement, no prerequisite to commence disciplinary action. Okay, so we're out of the 3214 world. You don't have to suspend a student at all. You could just be worried. Okay. But you're going to need evidence to substantiate your concerns. Under these rules, the hearing is expedited. All right. So it's an expedited hearing, will be completed within 20 days of the due process complaint, resolution session within 10 days. So it's a quick process. We used to not really consider this option that much, at least around here. It's sort of, what we think of as the nuclear option. All right. We're initiating a lawsuit against the parent to try to remove the student from their educational placement. We don't generally like to take that position. There's certain times we can. We typically don't unless we feel like we have a really good reason to, for a number of reasons. Why? Like, number one, at that point, your relationship with the family may not be that great, but suing them doesn't help the relationship. All right. So the other one is it requires a board resolution. All right. If you're initiating litigation, you need a board resolution to go down this to go down this road. Sometimes we just don't want to deal with that. But I think the main thing is like just souring the relationship with the family just leaves a bad taste in everyone's mouth. Makes us reluctant to do that. But we are seeing a willingness to consider this option more in the absence of available appropriate placements. We can't get the student, or we have a placement that we think is appropriate for the student. Parent won't accept it. There aren't any more, and keeping them in school is no longer an option for maybe a number of reasons. Maybe we're really concerned. Maybe we're getting pushback from staff, that staff are scared to be around the student. Those are legitimate concerns that you have to navigate. And, factors that play into the discussion when we think about this. The other reason that we are considering this now more, and it's a rule it's not a new rule, but one of the advantages to doing this is under the rules, you have an automatic pendency. Pendency is in the IAES. Okay, until the hearing is done, pendency is in the IAES. So at a minimum, you get some kind of reprieve. If you need the student out of the building. You have this comes along with that. Okay. Is there anything else you want to say about that? Is there anything else you want to say? No. Okay. All right. So the legal standard is, like I mentioned, you're going to have to show that maintaining the student in their current educational placement is substantially likely to result in injury to the student or others. That's not clearly defined. What is substantially likely to result in injury to the student or others mean? Okay. Does it mean serious bodily injury? Like we talked about, that's a pretty high standard. That's not in the regulation. It just says substantially likely to result in injury. Okay. And so the way our view is, it's not that serious bodily injury standard. And at least one regional associate has confirmed that. Okay. But hearing officers have the authority to exercise their judgments after considering all the factors. So your job, or our job rather, when we're in that situation is to lay out the evidence to prove to the hearing officer that keeping the student in school is very likely to result in the student being hurt or somebody else being hurt. Okay. So here the factors, what are they going to look at? Okay. What's the history here? Is this the first time? What's the reason for the concern? Is the student engaged in, have they hurt anybody before? What kind of aggression have they displayed? Is it just verbal? Is it just physical, or is it just physical? Is it just verbal, or was there physical aggression too? Going down this road and trying to ask for an IES with just verbal is going to be difficult. Now, nobody wants to be in the position where they have to. You might be asking, well, are you saying that I have to wait until somebody gets hurt? I'm not saying that. Okay, it depends on the situation. It'll depend on other factors. What have we done to address the behavior in the past? Is it getting did we do an FBA? Did we do a BIP? What are teachers seeing in the classroom? Are they noticing an escalation in behavior as well? Are the durations of behavior increasing? Okay, so all those things will be relevant. All right, so here's an example where the standard was not met. Okay, in this case, 17-year-old. Okay, so we have a high school student with ADHD and ODD. Shoved a desk into the thighs of a substitute teacher and punched her wrist after she confronted him about wearing headphones. So Interestingly, in this case, the IEP mentioned that the student did not do well when he was confronted by authority. The substitute was not given a copy of that IEP. Okay, and that will be relevant in the hearing officer's decision. So yeah, I'm seeing some grimaces. The misconduct was determined to be a manifestation of the student's disabilities, but the district told the parents he couldn't come back, that they were seeking an IAES on the grounds that he was dangerous. And also they would not do an FBA. They've refused to do an FBA outside of the context of an IES. Also not a great look. So the district's position was that this was the culmination of an escalating pattern of angry, threatening behavior. So they pointed to 2 instances in the past 3 months. So in the first one, the student yelled profanities at an aide, threw a basketball against the wall and said, "Shut the F up or I'll kill you." Pretty concerning, right? In another incident the month prior, a teacher confronted him about copying work. Student got in her face, yelled, called her the B word, later slammed the door during a discussion about the incident with the principal. Now, I'm in that situation. That's pretty concerning. I'm sure that would be concerning to a lot of us. And you're worried, understandably, about what the student could do if they're there. Or if they continue to be in school. But according to the IHO, despite the previous incidents, the record didn't support that he was substantially likely to injure himself or others if he stayed in school. There was no mention of either of those 2 events in the progress reports or evaluations. The teachers who he had, there was no indication from them that they were seeing any differences in his behavior. They didn't notice any increase in anger or shorter fuse. And I think really here the IHO found that had the sub been given a copy of the student's IEP, which said, has anger issues when confronted by authority, the whole situation could have been avoided entirely. So not great facts to go to the hearing officer on to ask to remove the student to an IAES. So if there's one takeaway there, hopefully you have procedures in place for your subs to, know what's on students' 504 plans and IEPs, so you don't end up in a similar situation. All right, now here's an example where the standard was met. El Segundo, California. This student was a younger student involved in several different behavioral incidents, grabbed the staff member's arm, grabbed the backpack of another student, tried to hit others and shouted, "I'll kill you." When staff tried to intervene, she lunged at them with fists swinging. There were a couple incidents of that. This student eloped frequently, balled her fists at aides saying, "I'll kill you." That should say 2016, by the way, I apologize. Between August and October 2016, the assistant principal had been punched, slapped, kicked, and pushed and injured at least 5 times. Similar incidents occurred throughout the year. So to this district's credit, they made several attempts, contrast that to the other case, made several attempts to address the behavior, including conducting an FBA, developing a BIP, providing an aid, and implementing other interventions and supports. So what happened was they kept her in school. She finished that school year, went through ESY at that school year. When it came time for the beginning of the year, they recommended an out-of-district. Parents didn't want it. Okay, so they asked the hearing officer to remove the student to an IES, and the hearing officer agreed with the district. Now I didn't mention that, but I will. Basically, the hearing officer said that it was abundantly clear the district was unable to address the student's needs during the previous school year, despite that she attended ESY without incident. So usually what you find is the more distance, the more time there is between events, the harder it is that it's going to be to convince a hearing officer that this student is dangerous. It's going to end up hurting somebody. But this student, finished the school year, went through ESY. But based on all the interventions and everything the district had already tried, kind of to no success during the previous school year, the hearing officer sided with the district. So being able to show that you have done what you can to address the behavior and that it's not working will be very, very helpful. Not saying you have to do everything you can think of or that you have to exhaust everything. Again, it's going to depend on the facts. But generally speaking, the more you can show that you've tried to address it. If you've not done an FBA and you're asking a hearing officer to remove the student from its placement, it's going to be an uphill climb. All right, so important factors, prior incidents of physical aggression. Okay, the absence of physical aggression evidence is going to make it more difficult, not impossible, but more difficult. Prior physical injuries. Again, we don't want to have to be in a position. We don't want to wait till somebody's injured, right? We absolutely don't want that. But again, if we don't have that, that could make it more difficult. So I guess what I mean to say is if this is the first, if you're going to a hearing on the first time the student, strikes somebody or assaults somebody, depending how serious it is, maybe very serious, may warrant that. But, the more history there is, the better. Increasing severity, documentation that shows a pattern of increasing, more intense behavior, or that shows that incidents are increasing in duration may also support a hearing. A hearing officer needs something to hang their hat on. So that will help. Prior attempts to address behavior, we already discussed, and we already also discussed remoteness and time. If you have, a student makes a threat and the last time they did something was last school year, you're going to have a tough time convincing a hearing officer that's keeping the student in school is going to result in substantially likely to result in injury. Okay. I hope that helps. So, interesting about one. So we talked about can't exceed 45 days. When this process is over, let's say the hearing officer agrees and they remove the student to an IES for 45 days, you can repeat this process. You can go back to the hearing officer again and say, we still think this student is substantially likely, keeping the student here is going to result in injury. You can renew this process. Not so with the other one, under the disciplinary context, but here you can, if you're initiating the due process complaint.
Thank you. We just had one quick question. When the IAES is to be determined by the CSE, that's in the first scenario, that's following a nexus and then finding when the 3 criteria are met. It's to be determined by the CSE, and that should be memorialized in an IEP document. And that's the program. And but we had a question from someone on Zoom with that, so thank you for that.
Okay. Great. So it's so good to be with you here today. My name is Candace Gomez. I'm the co-chair of the School Law Practice Group at Schoeneck King. I work primarily out of our downstate offices, Long Island, New York City, and Westchester. So it's a real pleasure to be here in Buffalo. I had the privilege of being here in the fall for the fall program, and it's always great to catch up with my wonderful school law colleagues, Andrew, Jeff, and McGinnis. We've got a great team in the Syracuse, Rochester area as well. So really a privilege to be here with all of you today. The section that I'm going to cover is one that deals with something that has not caused any controversy. No one's really been talking about it. It's a pretty mundane issue, and that issue is the Trump administration. Right? No, nothing, inflammatory there, nothing exciting for us to talk about. But no, we're not going to be talking politics, but we are going to be talking about the ways in which the new administration has led to some significant changes within the U.S. Department of Education's Office for Civil Rights. And I want to be clear that as we're going through this, we're not talking about it from a political lens. We're talking about it from a legal lens in terms of how it's going to impact the types of cases and the ways in which these cases are being handled by OCR moving forward. So we know that in March of 2025, there were a number of office closures, in particular, the Boston, Chicago, Cleveland, Dallas, New York City, Philadelphia, and San Francisco OCR regional offices were closed. Now, just looking at this list, it may seem that, okay, we're talking about 7 different offices. What significance does that have? I think it's important for us to recognize that those 7 offices that were closed, they oversaw half of the nation's states, and that basically impacted nearly 60,000 public schools and over 30 million K through 12 students. So the closure of those 7 offices, of course, is very, very significant. There are offices in Atlanta, Denver, Kansas City, Seattle, and DC that remain open, of course. 21 states have filed a request for an injunction against the layoffs, basically arguing that those offices should not have been closed and that the office closures and massive reduction in force is equivalent to incapacitating
key statutorily mandated functions of the department, causing immense damage. So we've heard a lot of talk about whether or not a presidential administration can basically shut down the Department of Education on his own or her own volition, or does it need some type of congressional authority or some other outside factor to be able to do that? I believe that what these states are arguing is that this seems to be an end run around having some other oversight, meaning, okay, we're not going to completely abolish the Department of Education, but we're going to hobble it so significantly that it basically becomes ineffective. That's what these states are arguing is happening due to these office closures. Another thing to keep in mind is, what are these offices responsible for in the first place? We know that OCR is tasked with enforcing federal civil rights law. This includes many different laws. The main ones that they encounter are Title VI of the Civil Rights Act of 1964, and that legislation prohibits discrimination on the basis of race, color, and national origin. The OCR offices also cover Title IX, which of course prohibits discrimination on the basis of sex, and Section 504, which prohibits discrimination based on disability, in addition to the Age Discrimination Act, which of course prohibits discrimination on the basis of age. So many of the key federal civil rights protections that we encounter are basically being overseen by the OCR. So the closure of these offices, of course, has a real effect. As we move on to talking about the OCR shifting substantive priorities, we should keep in mind that in January of 2025, OCR initiated a directed investigation into Denver Public School District regarding a gender-neutral restroom. So we think about the closure of these offices and the severe reduction in staff. It begs the question, well, what is left to do and who is going to do it? We've got to make some real priority decisions if we've got a reduced staff in terms of what is going to be investigated and what cases are actually going to be brought to the forefront. We've got to also keep in mind that there were many, meaning thousands of cases pending at the time that this shift took place that are now basically kind of just hanging in the balance in no man's land, where we don't know if they will ever be closed out or how they will be handled because there's insufficient staff. But we do know that there are some cases that are still making their way to the top of the pile, so to speak. So in the case of the Denver Public School District, the Office for Civil Rights began an investigation for discrimination against its female students in that school district because the school district converted female restrooms, or at least one female restroom, into an all-gender restroom in the largest high school within that district, which resulted in that school having an exclusive restroom for male students. So the males had their own restroom, but there was no exclusive, meaning only female restroom for female students on its second floor. I think that factor is significant because some of the news reports have portrayed this as basically the girls don't have a restroom of their own. This was on one floor of the school building that the female students did not have a dedicated restroom, but there were certainly other female dedicated restrooms within the building. The OCR team decided that they would move forward with this investigation because they believed that there was a Title IX violation because the female students were not being provided with comparable facilities to the facilities that were being provided to male students. And because of that, there was an allegation of discrimination based on sex. So we're seeing anything having to do with gender neutrality and restrooms being brought to the top of the pile. Of course, a lot of that stems from the administration's very clear pushback to many of the transgender and gender neutral policies that were implemented by previous administrations. Another case that has made its way to the top of the pile was in February 2025, OCR initiated a directed investigation into the Maine Department of Education regarding its trans-inclusive student-athlete policy. Now, I want to point out that both the Denver Public School District case and the Maine Department of Education case were directed investigations, meaning this wasn't a student or a parent who was upset or felt that they were slighted in some way. This is OCR on its own initiative going in and saying, we don't like what you're doing here, school district, we are going to basically be the ones complaining, and we are going to start the investigation because we think something is wrong, not as a result of something that was happening that prompted a student or parent to bring it forward to OCR's attention, which of course has made a lot of people somewhat worried because they're saying you have stacks of thousands of cases that have actually been filed by parents and students that are waiting to be seen and to be heard, and they're being ignored in order for OCR to go after its own mission and to go after its own cases that it believes are important enough to investigate. So there's some incongruence there, and there's some concern on the part of people who have been handling these OCR cases in the past. In the case of the Maine Department of Education, there were allegations that Maine continued to allow male athletes to compete in girls' sports, and that it was denying female athletes to have female-only restroom facilities and locker room facilities, similar to what we discussed in the Denver case. Now, we know that Maine has responded with a statement from its attorney general saying that the state will do everything in its power to defend Maine's law. It seems that the state of Maine and the federal government is at somewhat of a stalemate at this point in time. There is an understanding that there's some type of resolution agreement that may be in the works, but that does not seem to have been finalized yet. So we're waiting to see how that will pan out. And of course, one other thing I'll mention before we lose or before we move from this slide is federal funding. That really is the key issue when we're talking about all of these investigation issues, not just an administration that may not like what a school district is doing and they're at odds concerning their mission and goals, but we're talking about real dollars and cents. If this federal administration does not like what a particular school district is doing, can they and do they have the authority to pull that federal money from the school district, which of course has a ripple effect in terms of the services that can be provided to the students in that district. Now, as we continue to talk about the OCR shifting substantive priorities, there was an April 2025 letter to K-12 states that were asking them to certify that they would not engage in the use of illegal DEI practices or they would risk losing federal funding. I remember well when this came out last month because it resulted in a lot of confusion and questions, not just from our school district clients, but amongst the attorneys themselves, because number one, we were saying, what is an illegal DEI practice? Has that ever been defined anywhere? Certainly, we know that improperly discriminating against one group is prohibited. That's been the law forever. But is something like having an affinity group for students of a certain color or celebrating a certain cultural or religious holiday, is that going to be deemed as an illegal DEI practice? All of these questions were raised, which have yet to be actually defined and explained by the administration in terms of what they mean by illegal DEI practice, which put districts in an awkward position of saying, how can we certify that we're not doing something that is illegal when we don't know what it is that could be illegal? And fortunately, in New York State, individual school districts were not required to make that determination on their own because we are governed by what's called an SEA, meaning the State Educational Agency. So this is not true for every state. Some states have what we call an LEA model, which is a local educational agency in which each local school district is basically accountable and has a direct line to the federal government. Here in New York, we have the SEA model, where our state educational agency, our New York State Department of Education, basically is responsible for passing through funds from the federal government and for having oversight over those local school districts. So our New York State Department of Education kind of took that burden off the local school districts and said, we will submit a response on behalf of all of the local school districts to the federal government. And of course, we know that New York State has been, through its leaders when it comes to federal legislation, at odds with the president. So it hasn't been a cooperative and amicable relationship, but New York State Education Department has submitted a response on behalf of the individual school districts. So there's no need for each school district to go ahead and certify whether or not they're engaging in what the administration refers to as illegal DEI practices. changes to the OCR complaint processing manual. This is a pretty interesting change because there's no formal definition of a complaint or requirements of what a complaint must include. But we know that back in 2022, that OCR complaint processing manual excluded certain categories from the definition of a complaint. So, for example, if a school district received an anonymous correspondence or that anonymous correspondence made its way to OCR, or if people were reaching out to OCR for questions that were only seeking advice or information from OCR, they would reject that. They would also say that's not a complaint. Or if there were allegations that were communicated to OCR only orally over the phone, but no one actually put anything in writing to their office, they would say this is not an official complaint. We're not going to take the anonymous complaints. We're not going to take everyone who calls up over the phone and has a concern that they raise to us. We're not going to take on every person who just kind of wants to edify themselves with some new information. Those are not complaints that we're going to entertain. Those categories are no longer excluded under this administration as topics that would not be considered a complaint. At this point in time, OCR is saying that they are going to consider any topic in those categories on an individual basis to determine whether or not that information provided is subject to further processing. And OCR is going to determine whether it is appropriate to obtain some type of interim relief for the complainant, meaning some type of stopgap measure that a school district must do in order to correct what the person is complaining about until a final decision is rendered. Again, another interesting development because I've told you about the stacks and stacks of cases that are piled up waiting to be seen. So now we're expanding the scope of what could be a complaint, meaning even more areas could be considered complaints, and yet still we don't have the adequate staffing or resources to address these concerns. So when we're thinking in a practical way about what complaints OCR actually is going to be able to process and it's actually going to be able to rule on right now, I think the general consensus is that for the most part, if there are OCR cases involving transgender students or complaints about gender neutrality, that has a high likelihood of making its way to the top of the pile, as I mentioned, and being investigated by OCR. Likewise, if there is a complaint regarding the school district's DEI practices or some type of racial discrimination claim, that also has a high probability of actually seeing the light of day and being investigated. All of the other complaints, the 504, the age discrimination, all of the other categories that I mentioned, we don't know that there will actually be the manpower to handle and cover those cases at this point in time and perhaps for the foreseeable future. As we talk more about changes to the OCR processing manual, we may see more directed compliance reviews where OCR is the body that initiates the process to address the possible discrimination without receiving an OCR complaint. I talked to you before about the situation in Denver and the situation in Maine, in which OCR is now taking a new proactive stance where they're saying, we are going to look into situations on our own. We're not waiting for that complaint to cross our desk. And OCR has also indicated that it will use mediation and rapid resolution to address complaints related to harassment as well as disability-related complaints. So for those who believe that OCR's moves are actually in the right direction, this may be some supporting evidence of that, where OCR is saying, we recognize that we don't have the staff that we used to, but when it comes to those other types of complaints, meaning harassment or disability-related complaints, the way that we propose fast tracking that is we're going to use mediation in ways that we haven't used it before. We're going to rely on that a lot more heavily. And we're also going to seek out these rapid resolution steps so that cases don't drag. So that is a possibility. For those who believe that OCR's new position is the correct one, it could turn out to be true that those cases will continue to be handled, but just in a different method, whereas mediation and rapid resolution is used more heavily than it has been in the past. And I think that sums up my topic. Are there any questions before I turn it over to Jeff again? Thank you all so much.
Thank you. Thank you, Candace. We're seeing great information. We're actually seeing, it's just a guess, we're seeing an uptick of these type of claims that used to go to the state, to OCR, to the New York State Division of Human Rights. So that's like, the claims have to go somewhere. And so we're seeing that. We'll see if that trend continues. And, State Division of Human Rights, they pose certain challenges as well in terms of how they investigate and timeliness and so on. So, all right, well, we're finishing up with something light, fun, sports, right? We love sports. Let's enjoy some sports. So let's start with the general rule. We all know if a student with a disability is in a classroom, we have to accommodate. That's 504, that's IEP. That's all we talk about all the time. But that obligation does not end at the doorway. It continues to any school-sponsored or school-related activity, any. And that includes field trips. That includes extracurricular activities. That includes sports. And we're going to talk about sports today. By the way, this comes, not me talking, it's the federal regulations, which I've cited right there. I am surprised that not everybody knows this. I do occasionally, maybe somewhat regularly, hear, well, it's a volunteer event, or they're not entitled to participate, or they don't have to participate, or it's after school, or it's outside of school. And that just doesn't fly. If it's connected to the school, if it's school-sponsored, school-supported, we have to accommodate. So one of the biggest areas, though, is sports. So we could do a whole separate presentation on field trips and those type of activities. The principles that we discuss now apply to them as well. So what's interesting with sports is there are two types of sports events. Some events are there are eligibility requirements. In other words, you need to make the team. Not everybody can be on the varsity baseball team. But the other is types of events that everyone participates in, open gym night, a club, if the chess club, which chess is a sport, right? We get to discuss are these sports or not. So the type of event is relevant to the questions we ask. And when we go through the analysis, we have to focus on that. And again, an analogy would be also, the same thing, kids trying out for the baseball team, just like they're trying out for the school play, same concepts. So, some school-sponsored events are generally open to all students, intramural, open gym night. For these type of events, the students with disabilities must be provided an equal opportunity to participate. They can be excluded but it's just like, similar to employment accommodations for employees. If they're unable to meet the essential requirements of the activity, even with accommodations, we could exclude. So what does that mean? Well, if it's open gym night and you have a student who is interfering with the activity and knocking into kids and disturbing the game and blocking the game from taking place, if we can't give that student an accommodation to stop that, we would have grounds to exclude them. Now, from a procedural standpoint, if we're determining which accommodations we should provide, this is for any activity, someone has to figure out what do we need to give the student to get him or her to participate. It's supposed to really happen at a CSE meeting or a 504 meeting. But if you can work it out to the parents' happiness and it's successful without a meeting, that's fine. No one's going to complain. But it's when we say you cannot participate, you cannot go to the open gym night, you cannot go on the field trip, you cannot go on the trip to Europe. If you're going to say no because we don't feel we could accommodate you without you altering the trip, you need to have that decision made at a CSE meeting or a 504 meeting. You don't want a principal saying, sorry, you're not going on this trip because you're disabled. The principal might be thinking, okay, that's going to be the outcome. I need to have a 504 meeting with the parent, with a group of experts, with the doctors, collaborate, follow the procedure. Because a lot of parents get upset and they'll challenge this. And if you don't do this at a 504 meeting, we're going to lose. It's that simple. So let's make sure we have it. If we're going to say no, do it at the right setting. So let's talk about some events. Here's something interesting. The Wiffle Ball Club. Okay, that's my kind of sport. Let's go get that yellow bat and that ball with the holes in it. So open to everybody. But the district actually said, we don't think you could play because we don't think you can medically tolerate this activity. And ultimately, there was a settlement here. OCR, as Candace was saying, they got the mediation. And what happened was the parent got a doctor's note, said student could participate safely, and they were able to play. Now, that doesn't seem like a big deal. Like, of course, you got a note. But what it shows is the district has the right to interact and question if you could safely participate, and we should figure it out. And if the district cannot unilaterally make this decision without going through a process and actually getting the right answer. Don't make an assumption. You don't say, oh, kids with this disability can't play. Get the doctor to talk about this specific student. Now, let's talk about reasonable accommodations in an event itself. So here, open gym night. Here we have a situation where they're an open gym night, and the district didn't want the student to participate, but it was determined that with a personal aid, it would work. So the district said, well, do we have to provide a personal aid in an open gym night? And the answer was yes. So if the personal aid will do the trick, then we have to provide it. And it doesn't matter the cost. If you're looking at the cost, very rarely is that going to be a defense. Because you might say, oh, the budget for the open gym night is $500 and it will cost $300 to have an aid. That seems like a burden. That's not how they do the analysis. They say the budget for the school annually is $100 million. The aid is $300, not a burden. So same rationale for the after school program or the trip or so on. It's hard to get it on money. Now, let's talk about sports activities. There's another angle here, it's discrimination. You could say, hey, I didn't make the team because I'm disabled. You discriminated against me. You must have known I'm disabled, therefore kick me out. So here you have a case in 2013 where a student with a disability didn't make the varsity hockey team. There are 16 spots for the team. 28 kids tried out. So, I'm sorry, 28 kids didn't make. So 44 kids tried out, 16 made the team, 28 didn't. And he said, you must have not picked me because I'm disabled. So again, it's kind of weird. You want to show, did we give the student the same opportunity to try out? We can't assume you'll never make it. They have to try out. This was not an accommodation situation. It was simply a fact-based decision where they had to show that this student wasn't good enough, wasn't in the top 16. So there are lots of reasons why someone could say, I didn't make the team, I didn't make it because of race, gender, religion, disability as well. It's always good to have great data for the coaches to show that they tried. Now, again, this is a situation, it's not an accommodation case, just pure discrimination. Now, here's a flip side. This is an accommodation case. 2012, this is an unbelievable case. High school swimmer suffered from anxiety and fear of drowning. Okay, you're probably thinking the same thing. Wait, what'd you say? Okay. Yeah, so I figured out, let's do lacrosse, basketball. Now let's do swimming. So this student was a good swimmer, great swimmer, made the team. But had such a fear that she missed practice. And the rules were, you have to go to practice. And the student said, I'm not going to practice because I'm afraid I'm going to drown, and I might also miss a meet or two. So the coach said, you're off the team. And the student said, that's discrimination. It's because of my disability. That's why I couldn't participate. And the district won. You do not change the criteria for a student with a disability. That would be a modification. We only accommodate. A small modification might be okay. But to say we're going to exempt you from the requirement that you have to practice is a modification. It's a bridge too far. So they lost. Now, let's look at it the correct way. Was there an accommodation that we could have offered to give the student to participate? Do we need to give counseling to the student? Do we need to give a personal aid to the student with a plan when the student has anxiety to go through steps to get her back in? That would have been a reasonable accommodation. Now, why? Because they're outside. What if the swimmer in the events needed the aid to swim right next to her? That's not allowed. That's a modification. You can't alter the event. So very fact specific and interesting information. So here's another one. Football. My kids never played football because I couldn't tell. I imagine their grandmother would not allow that. You playing football or what? But football, here you have a student who had multiple issues, medical issues, and the student said, I could play football, but I need additional abdomen padding, more than a typical player is allowed, internal heat monitor, and direct medical supervision. If I could do that, I could play. And the federal court said, no, that's altering the activity. You're giving someone an advantage. Now, to me, a heat monitor in itself, I don't think that's altering, giving anyone an advantage. Direct medical supervision, as long as it's not on the field, that seems okay. But additional abdomen padding, that's going to give them an advantage. And if that's what you need, then that's a modification. So that's not allowed. If we're recommending an accommodation for an extracurricular activity, yeah, you should put it on an IEP or 504. It'd be nice to have. But just one thing though, you have to be careful that you don't put on the IEP, the student needs to participate in the activity for a FAPE, or the student must participate. This is simply, if he participates, if he's eligible to participate, then he would get this, because that's the trick, the trap that someone could fall into. Because I'm going to talk about a scenario in a second where we could fall into that trap. Well, I start with, you can show them these materials, but I could come out, but you'll see the last case is right on. Now we get right on. So here's another one where 2012, student with diabetes, high blood sugar, needed to check during practices. And the coach said, I'm not allowing you to check. We don't do that here. And obviously that's not going to happen. You hope it doesn't happen, shouldn't happen. But again, that's not altering the activity. It's on the sideline. So that it does extend to that situation. Now, sometimes the accommodation gives an unfair advantage, and that's not allowed. So if it's medical treatment on the sideline, that's certainly allowable. But a really good, about 12 years ago, OCR wrote all this stuff, kind of surmising situations about what about a student who cannot hear on the track meet and they can't hear the gun? Well, they wanted a flicker, and that was viewed as a reasonable accommodation because they'd see the light. But I mean, what if somebody says, actually, you see quicker than you hear? Could that be an advantage? I don't know. I'm just making this up. What if it's a 5-10 second race versus a 3-hour race? Who knows? Some interesting info. They talked about a student with one arm who is swimming and has to, you're supposed to use 2 arms against it. Couldn't you just say one arm is allowed? Is that an advantage? Because if it is an advantage, then the student might not be able to play, which would not be good. So a lot of interesting stuff. In terms of eligibility requirement, this kind of follows up on the question from before. The eligibility requirements that have nothing to do with participation, making the team. A lot of schools say no pass, no play. If you're failing a class, you're not eligible to participate. If you didn't attend school that day, you can't participate in the afternoon. Do those apply to students with disabilities? And the answer is yes, absolutely. And so there was a decision from 2000. This is a long time ago, but I know this. This is my case, and so proud. I showed that. And so a student was failing, was deemed ineligible, and the parents said, "Hey, it's discriminatory. I shouldn't have to pass. I shouldn't be subject to that requirement." And the state review officer said, "No, you should be. As you have an IEP, that evens the playing field. But if we put in the IEP needs to participate for a FAPE, that could supersede this. So something to don't put that in the IEP. Be careful about that. So going to we have 2 more. Going to let's see here. Notification. You need to if there's an opportunity, a sports game, a varsity team tryout, you need to communicate that information to all students. If you don't communicate it to students with disabilities, that's viewed as exclusion. So if it's on the website, that's great. If you're only emailing certain kids, that's not so great. Make sure all kids are invited to participate. And then let's talk now about the recent case here. This is from 2 months ago, and now it's Brighton School District 27J in Colorado. This is not the district near Rochester. This is the one in Colorado, and very interesting. 18-year-old student, learning disability, autism, and was on the basketball team, and the coach refused to implement her IEP during practices and games. He just said, and he just said, we don't do that here. The background, the student had several learning disorders. She struggled to complete tasks and understand directions. She needed her work assignments to be chunked into small pieces. She made the varsity basketball team. The coach refused to play her because she couldn't remember the plays. This is a pretty interesting case. So the coach said, you don't know the plays. I'm not playing you. And she said, well, if you taught it to me consistent with my IEP, I would know the plays. I don't know at the end of the day if student's going to win or not on this. This is interesting, but the coach didn't even try. He said, I don't do that here. And then he made a comment. See, he made a comment about certain groups of disabled kids, which was pejorative in nature. So that colors the claim as well. So, so the parents moved to dismiss on several grounds. The court did not get into the merits of whether or not this would or would not be a reasonable accommodation because it's the early stage of litigation. But the court said, yes, this is a valid claim that could potentially be prevailed upon. For some reason, the district said it's just a coach, not a teacher, so therefore we're not liable, which is not a good argument. Okay, that the coaches have to accommodate. So ultimately, though, we'll see whether or not they'll win. But now, is it reasonable for a coach to communicate in a certain way? Maybe. I've seen like a quarterback with a learning disability and a complex book. That would help a student, and that would be a reasonable accommodation. However, looking at it from both, if the coach could say, there are times when I need to come up with things on the fly immediately, brand new, is that it? Because if he says, I do stuff brand new, and you won't be able to follow me, he may have a point. The coach may have a point, but then you have facts. There'll be a deposition. How often does that happen? When was the last time you came up with something you never worked on? So I'm not saying it's an automatic win for the parent because it's early, but it shows that, is there an accommodation? Is it reasonable? Are we altering the activity? That's all we're supposed to look for. So maybe in the future, we'll have an update on this case. But what one thing to kind of get out of this, let's face it, this is complicated stuff. This, and you got a lot of kids with disabilities playing a lot of activities. How do you keep track of this, and how do you get ahead on these accommodations? You don't want to do it at the last minute. You don't want to do the field trip the day of the trip. You don't want to do the activity the day of the practice or the tryout. One thought, if you're at a 504 meeting, an annual review, i.e. for CSE, you should ask the student, what do you got planned for this upcoming school year? Anything unusual? Anything new? Any field trips? Are you thinking of going on the trip to, boy, these kids, let me tell you, when I was a kid, if we went like to Baskin Robbins or ice cream, that was a great trip. Kids are going to Florida. Kids are going to Europe. These are heavy duty programs, lots of activities. Get ahead of them, have meetings, see if they could be accommodated. If you can accommodate, you have to. If you can't, at least you went through the right process. So that's all I have right now. Any questions? If you have questions, one question, yeah. Well, that's a good question. If the student, I think for a coach, you have to make a determination as to whether or not it's needed. And I know most coaches don't sign off. The coach is one of the people who are not automatic. So there has to be a determination made as to whether or not the coach should know. So if a student has diabetes, you want the coach to know, or so on. All right.
Hi, Jeff. We have a question from home. If a student has a 1-to-1 aide on their IEP, would they be entitled to an aide at a school dance?
It depends. It depends. Probably you ask yourself, why does this student need an aide during the day? And will that need carry over into the event? Now, when I'm thinking the most kids in the class are, say, 20, and the dance might have 100 people, you're probably still going to need an aide. This is my guess. It depends what it's for. However, what if it's 20 kids going to the chess club and there's only 2 kids? Do you need an aide there? Maybe you don't. Maybe you do. And also, what is the aide for? If the aide's there for a medical reason and there's going to be a nurse at the event, maybe you do, maybe you don't. It depends. So you have to go through the analysis and figure it out. Great question. All right, everybody. Thank you. Hopefully we'll have a nice webinar over the summer, and we'll be back in the fall. Have a great time and end the year strong, and I'll see you soon. Take care. Bye-bye.